Hello everyone, welcome to Linda Liu IP course. My name is Yongjie Song, a patent attorney from Linda Liu and Partners. If you have followed our previous videos, you may recall that my colleague Peter has already introduced the fundamentals of third-party observations, including the legal basis and procedural aspects. Today, I will not revisit those basics. Instead, I would like to focus on sharing practical skills and strategies for effectively submitting third-party observations, helping you leverage these powerful defense tools more efficiently. First, I would like to introduce the advantages of third-party observations, as many of our clients have inquired about this topic. Compared to post-grant invalidation procedures, third-party observations offers the following main advantages. First, preemptive interception and low cost. That means third-party observations can be submitted before the patent is granted, with no official fees. They can effectively prevent the grant of the target patent applications or limits its scope of protection, reducing the risk of threats or even lawsuit after the patent is granted, and saving potentially high costs associated with the invalidation and litigation. Second, simple procedure, no direct confrontation. The submitter of third-party observations may choose to remain anonymous, only providing written opinions and evidence to the Chinese Patent Office, without directly confronting the applicant of the target patent application. Supplementary communication, dynamic adjustment. After submitting a third-party observations, attempts can be made to communicate with the examiners via telephone to understand the examiner's inclination and attitude towards their opinion. This helps in dynamically understanding the examination progress, and if necessary, supplementing new reasons and/or evidence, thereby more precisely and efficiently influencing the direction of the examination and increasing the likelihood of the third-party observations being adopted. Now, let's focus on the tips and strategies for submitting third-party observations. Although TPO can be submitted at any time between the publication of an invention patent application and its grant, strategic timing is critical for maximum impact. We recommend submitting between the publication date and before the issuance of the first office action. At this stage, the examiner has not yet formed a preliminary conclusion, making them more open to external inputs. Additionally, this allows sufficient time to prepare a well-reasoned and evidence-backed submission. Waiting until after the first office action is issued often leaves limited time due to the applicant's response deadline and the examiner's time constraints, which may reduce the effectiveness of the submission. To be extra cautious, especially to avoid the risk of target patent application being granted directly, we advise preparing and submitting the third-party observations as early as possible, preferably soon after the application is published. Now, let's talk about how to draft persuasive third-party observations. When drafting a TPO, focus preliminarily on novelty and inventiveness, but do not overlook non-novelty and inventiveness. Provisions such as insufficient disclosure, lack of support, or unclear claims, especially when the prior art we found is not strong. These non-novelty and inventiveness provisions serve as important breakthroughs. Furthermore, when addressing novelty and inventiveness issues, it is recommended to provide multiple argumentation methods, combining various prior art references. The advantage is that if the examiner does not accept one combination of evidence, alternative argumentation methods prepared in the TPO could provide the examiner with other options, thereby effectively increasing the likelihood of the opinion being adopted. Submitting the opinion is not the end of TPO process. It should be part of an ongoing engagement. To maximize the success rate of the observation, it is necessary to monitor the office actions. If opinions in office actions are positive for us, for example, the examiner rejects the inventive step of all claims, we can keep monitoring the applicant's amendments. But if the opinions in the office actions are negative for us, for example, the examiner does not adopt the reasons in the observations, and the patent application has chances to get granted without substantive amendment, a doable and effective way is trying to conduct a telephone interview with the examiner. According to our practice, most of the examiners are willing to talk, because that may reduce their patent search workload if the prior art the public submitted are strong. By telephone interview, we can further discuss reasons in the observations and understand the examiner's attitude towards the application. Then we can consider whether supplementary observations are required. It is also necessary to monitor the applicant's amendments. Although we can't see the arguments for the applicant from the inquiry system, we can obtain the amendments to the office action. If the observations do not cover the amendment, for example, the newly added features to the independent claims are from the specification, we can also conduct a telephone interview with the examiners to discuss the newly added features and ask the examiner whether other prior arts related to these features are required to submit. Then you could repeat the above steps after submitting the observations until the examination period is ended. Third-party observations are powerful, low-cost tools in patent defense. To use them well, remember these three things. First, submit early. It is preferable that TPO is submitted before the first office action. Second, build a strong case. Use multiple arguments from different aspects. Third, stay in the loop. Monitor the prosecution, communicate with the examiner, and provide additional arguments and evidence if needed. By following these tips and strategies, you can help shape the examination, stop weak patents from being granted, or limit the scope, all without ever facing the applicant directly. That's all I want to share today. Needless to say, they are just brief tips and strategies for third-party observations based on our practice. If you have any questions, please feel free to contact us as a leading law firm in China. We are always glad to help. See you next time.